Can a bar be sued for selling alcohol to a drunk driver? A bar, a restaurant, or a liquor store could be found liable if they have sold an alcoholic beverage to an intoxicated customer. Many state legislatures have passed a version of what is known as a dram shop law. This type of law is known as a dram shop law because alcohol was previously sold in drams, which is a unit of measure. The argument in this type of case usually revolves around arguing that the alcohol did not cause the plaintiffs, the victims, injuries. What can happen in a dram shop case? In a case such as this, a bar, restaurant or liquor store could be found liable if they sold someone a bit too much alcohol. Two different types of dram shop cases exist. First-party cases. Third-party cases. Let's take a close look at each of these cases. First-party dram shop cases. In a case such as this, an intoxicated person would have been injured as a result of being sold too much alcohol. The individual involved has decided to sue the bar, restaurant, or liquor store for selling them the alcohol. However, some states do not allow first-party dram cases, and it is presumed that people should be responsible for how much alcohol they consume. While adults may not be able to bring about first-party dram cases, minors can. This is because minors are not legally allowed to drink. In a case such as this, the establishment that sold the alcohol to the minor has broken the law. Although cases such as these are not permitted in some states, they may still be worth pursuing. Cases such as these can be quite hard to win as the defendant will be trying to convince a jury to pay them compensation because they drank too much alcohol and were injured as a result. Third-party dram shop cases. In a case such as this, an intoxicated person injured another person. For example, when someone becomes intoxicated and is involved in a car accident, the individual who was hurt by the drunk driver can file a claim against the bar, restaurant, or liquor store. The establishment who sold the alcohol to the intoxicated persona is known as the third party in cases such as this. Proving liability. While negligence is the basis of many injury cases, in dram shop cases negligence is not considered to be an issue. Rather, liability is the issue here, and the case may be based upon the intentional conduct or the recklessness of the state's law. Recklessness. Reckless actions involve people being aware of but consciously disregarding a risk, whether there was unjustifiable or substantial risk that an unsafe situation may occur. In other words, if you were aware or you should have known that the action you were about to commit was likely to be unsafe but you did it anyway, the court is likely to say that you were reckless. The individual who served the alcohol would have acted recklessly if they intentionally served alcohol to a customer, knew that the customer was visibly intoxicated or a minor. They consciously disregarded a substantial and obvious risk that serving alcohol to the customer would cause them physical harm, or physical harm would be caused to others. Intentional conduct. In some parts of the United States, there is a very limited liability to their statutes surrounding dram shops. These states will only allow dram shop cases if there was intentional conduct. These cases will involve injuries to those who have had alcohol issues for years, or they involved injuries to minors. Some states use even further restrictions on dram shop cases. When minors are involved, some will only allow claims to be made if the server of the alcohol knew, or should have known, the minor was underage and that they were about to be driving a car. If despite all of this the server gave the minor alcohol, the server could be found liable.